Welcome to this explainer. You know, when we look at A-level law, proving a negligence claim usually feels like checking off three familiar boxes: duty of care, breach of duty, and damage. Boom, 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 right? But it turns out proving those three things isn't always the end of the legal story. Actually, it's often just the beginning of the battle.
Picture this. The claimant thinks they've won. They've dotted the I's and crossed the T's. They proved the defendant owed a duty, breached it, and caused them actual damage. They're practically already spending their compensation money in their head. But wait, the defendant suddenly pulls out a legal shield. The plot thickens. The defendant argues, hey, maybe I shouldn't have to pay full compensation. Or, you know what, maybe I shouldn't have to pay a single penny.
In the world of A-level law, defendants basically have two main shields up their sleeves to reduce or even completely dodge paying compensation. We call these defenses to negligence. The big two you absolutely need to know are contributory negligence and consent. You'll also hear consent called by its very fancy Latin name, Volenti non fit injuria. These are two radically different legal weapons, and it is absolutely crucial that we don't mix them up.
Okay, let's dive straight into Section 1, contributory negligence, also known as shared blame.
So with contributory negligence, the defendant isn't actually sitting there saying, I did nothing wrong. They're admitting some fault, but they're pointing the finger back and arguing the claimant also failed to take reasonable care for their own safety. The court is essentially asking two big questions here. First, did the claimant fail to take reasonable care? And second, did that failure actually contribute to the damage? If the answer is yes, we're looking at shared responsibility under the Law Reform Contributory Negligence Act 1945. Because this is all about sharing the blame, it's only a partial defense. It won't destroy the claimant entirely, but it is definitely going to take a chunk out of the claimant's final payout. To really get a picture of how this works, we've got to look at one of the most unforgettable cases in all of tort law, Sayers v. Harlow Urban District Council from 1958. Just imagine being trapped inside a public toilet because the lock is broken. Literal nightmare, right? Well, that's exactly what happened to Mrs. Sayers. After shouting for help and getting nowhere, she decided to literally climb her way out of the cubicle. She put one foot on the toilet seat and the other on the toilet roll holder. And predictably, the spinning toilet roll holder gave way and she fell and injured herself.
What's genuinely fascinating here is how the court ended up splitting the blame. The local council was 100% liable for the broken lock. They negligently failed to maintain it. But the judge looked at the whole situation and decided that her specific grand escape plan, balancing on a spinning roll of toilet paper, was, well, partly unreasonable. Because her own acrobatic choices contributed to her injuries, her damages were reduced by 25%. So she still won her claim, but she took home a quarter less than she would have if she just stayed put. Now, this whole principle of shared responsibility, it pops up all the time in road traffic cases. Why is that? Well, because as road users, we are all expected to take basic, common-sense precautions to keep ourselves safe. If you skip those basic steps and then you get hurt, the law steps in and says, look, you bear some of the responsibility here for making your own injuries worse. Let's run through three absolute classic cases that show this in action. First up, O'Connell v. Jackson. The claimant was hit while riding a moped, but he wasn't wearing a crash helmet. His payout? Slashed by 15%. Then there's Froom v. Butcher. The claimant didn't cause the crash at all, but he suffered way worse injuries simply because he wasn't wearing a seatbelt. That little mistake cost him 20% of his damages. And finally, Stinton v. Stinton. Here, the claimant actually accepted a lift from a driver he knew full well was drunk. That terrible decision to willingly put himself in danger reduced his damages by a massive 33%. The takeaway here is huge. In all these scenarios, failing to protect yourself literally costs you money, even if someone else entirely caused the accident.
So, the absolutely crucial thing to remember is that contributory negligence is merely a partial shield. It just trims down the damages mathematically. But what if a defendant wants to completely wipe out the claim, the whole shebang? Well, that brings us to our second, much heavier legal shield: consent.
Moving right along to Section 2, consent, the complete defense.
Because the consequences of this specific defense are so incredibly severe, we're talking about leaving an injured claimant with absolutely nothing, courts are super strict about letting defendants use it. You'll often hear lawyers throw around the Latin phrase, volenti non fit injuria. Translated, it simply means, no injury is done to one who consents. In plain English, if a claimant freely and knowingly accepts a risk, and then that exact risk ends up hurting them, they can't suddenly turn around and sue. If this defense actually succeeds, the defendant is totally cleared, off the hook. The claimant gets zero.
Naturally, because it wipes out the entire claim, the defendant has an incredibly high bar to clear here. They have to prove a really strict three-part sequence. Number 1, the claimant had actual knowledge of the precise risk involved. Number 2, the claimant had a genuine, unrestricted, free choice in the matter. And number 3, the claimant made a voluntary acceptance of that risk. I can't stress this enough. Just knowing something is a bit dangerous is nowhere near enough to trigger this complete shield.
A fantastic way to remember this rule is the 1977 case of Stermer v. Lawson. In this one, the claimant borrowed the defendant's motorbike and unfortunately ended up crashing and getting hurt. The defendant tried to argue in court, hey, come on, they knew riding a motorbike was dangerous, they obviously consented. But the defense totally failed. Why? Well, because the claimant had never been properly shown how to use that specific motorbike. Because of that, they lacked the knowledge of the precise risk involved. A general vague awareness of danger just doesn't equal legal consent.
We also see this super strict approach applied in the workplace, which was brilliantly demonstrated way back in the 1891 case of Smith v. Baker. A worker was injured by heavy rocks falling from a crane swinging right over his head. Now, he definitely knew about the danger. In fact, he'd actually complained about it before. So the employer tried to use the consent shield, basically arguing, well, he stayed on the job, so he accepted the risk. The court shot that down immediately. Knowledge does not equal free choice. The poor guy had little realistic choice but to keep working to earn a living, right? So he didn't freely accept the risk at all.
All right, let's hit Section 3, when consent fails, specifically focusing on rescuers and road limits.
Sometimes a sense of public duty totally blocks a defendant from using the consent defense. Think about police officers or firefighters. These people knowingly walk into danger every single day. Does that mean they just automatically consent to being injured by someone else's carelessness? Absolutely not. Take Haynes v. Harwood, where a brave police officer was injured trying to stop a runaway horse that the defendant had negligently left unattended. Or Ogwo v. Taylor, where a firefighter suffered severe heat injuries while battling a house fire that the defendant negligently started. In both situations, the defendants had the nerve to claim the rescuers consented to the danger. The courts firmly said no way. Acting under a professional, moral, or public duty to rescue someone is completely different from freely and voluntarily accepting a risk.
There's also a hard and fast statutory limit when it comes to road traffic accidents. Under Section 149 of the Road Traffic Act 1988, the complete defense of Volenti cannot be used for car crashes at all, period. The law deliberately blocks it because of the way third-party insurance rules work. Society wants injured road users to actually be able to access compensation. So let's say a passenger gets into a car with a drunk driver. The defendant can't use the complete shield of consent to get out of paying. They are forced to rely on the partial shield of contributory negligence instead.
That brings us to Section 4, applying defenses step by step, and getting that exam technique locked down.
Let's approach this methodically, exactly like a lawyer analyzing a fresh case file. We've got a foolproof 4-step sequence. Step 1. Is there actually a tort to begin with? Remember, a defense only matters if the claimant has successfully proven duty, breach, and damage first. Step 2. Was the claimant partly responsible for their own injury? Like, did they fail to wear a seatbelt? If yes, your brain should immediately go to contributory negligence. Step 3. Did the claimant freely and knowingly accept the precise risk? If they had full knowledge and total free choice, then you explore consent. And finally, Step 4. Check for limits. Was it a road traffic crash? Was the claimant acting as a rescuer under public duty? If so, consent is entirely off the table. Now, when you're writing about these concepts, nailing the specific legal vocabulary is absolutely essential. For contributory negligence, the magic phrases are partial defense and damages reduced. For consent, you want to use complete defense and talk about the precise risk. It's actually fascinating how strict the courts are here. You can't just throw out a vague argument like, well, they knew it was dangerous. That just won't fly. The law demands absolute precision. And trust me, so will your examiners.
So the core concept to permanently cement in your mind is the ultimate mathematical outcome of these two legal shields. It really just boils down to this simple equation. Contributory negligence equals less damages. It trims liability. Consent, or Volenti, equals zero damages. It completely avoids liability. One gives the payout haircut, while the other wipes it off the map completely. As we wrap up this explainer, I want to leave you with a provocative question to chew on.
When someone is genuinely injured by another person's negligence, but they also made a pretty foolish choice themselves, what does true justice look like? Should one bad decision cost you your entire claim, leaving you with absolutely nothing? Or is it fairer to just deduct a percentage of the compensation, acknowledging that there's plenty of blame to go around for everyone? Think about how the law tries to balance those scales. Thanks for joining me on this explainer, and keep questioning the mechanics behind the law.